Good evening, everyone. Welcome to PNAA's series on international nurses recruitment, what you need to know. Marife Sevilla will be doing the introduction. Go ahead, Marife, and please unmute yourself.
Greetings from PNAA to everyone, and welcome to this webinar brought to you by the PNAA Human Rights Committee in collaboration with the PNAA Global Affairs Committee. I am Marife Sevilla, the chair of the Human Rights Committee of the Philippine Nurses Association of America. Our committee have received numerous issues and concerns regarding employment contracts of newly arrived nurses. This webinar will describe the process of labor recruitment from government perspective and increase awareness on understanding the fine prints of contract between nurses and recruitment agencies. Now, may I call on the immediate past president of PNAA, Dr. Mary Joy Garcia Dia, who will be our program moderator for this event.
Thank you so much, Marife, and again, welcome everyone. The objectives of our program is really to describe the process of labor recruitment from a government perspective. We are pleased to have special guests that will talk about it. The second one is to increase awareness on understanding the fine prints of the contract between recruitment agencies and nurses. And lastly, to describe PNAA's advocacy work in addressing nurses' recruitment stories. Our program will be as follows. I will be introducing our panel speakers, The Role of Polo by attorney Angela Librado Trinidad, Understanding Contracts by attorney Felix Binluan, and lastly, Nurses Recruitment Stories from Ms. Virginia Alinsao. Each speaker will have 10 to 15 minutes to discuss their assigned topics. After our third speaker completes her presentation, we will open the forum for question and answer. Please use the Q&A icon that's located on the bottom of your screen to type your questions at any point in time while you are listening to our speakers. For those that would like to use chat, you are welcome to do so to post comments. However, our moderator will only read the questions posted on the Q&A. Again, our chat moderators will be Marife Sevilla and myself, and our Q&A moderators will be Madeline Yu and Emily Danuco. In case you are having any technical difficulty, Ms. Carol Robles and Dr. Dan Labinario will be able to assist. So now, let me introduce our panel speakers. Attorney Angela Librado Trinidad is widely known for espousing women's causes. She holds a bachelor's degree in mass communication and Bachelor of Law degree from Ateneo de Davao University. Angela is a staunch advocate for children and workers. This lady lawyer is a mother of 4 and a hell of a cook. Currently, she heads the Philippine Overseas Labor Office, or POLO, in Washington, D.C. as its labor attaché. In this role, Attorney Trinidad oversees the implementation of all labor employment programs of the Department of Labor and Employment. POLO's programs are geared towards protection and empowerment of our overseas Filipino workers in the United States and the Caribbean islands. When she is not preoccupied with work, she spends most of her time hiking and perfecting her vegan menu. Our second speaker is Felix Binluan. He is an alumnus of the University of the Philippines College of Law. Felix practiced labor and management relations in the Philippines for 6 years before migrating here in the United States. In 2006, Felix assisted the Sentosa 27 nurses who complained about the terms and conditions of their work environment. Since 2013, he has been representing low-wage earners such as nannies and housekeepers, as well as professionals such as nurses, teachers, and accountants in fighting for their rights as immigrant workers in this country. He is recently honored as one of the 3 recipients of NELA, New York's National Employment Lawyers Association Courageous Counsel Award for the year 2022. His firm's philosophy is premised on the protection of the individual's civil rights in the workplace and in combating any form of worker exploitation. Last but not the least, Ms. Virginia Alinsao, our third speaker, completed her basic nursing education from St. Paul University, Iloilo City, Philippines. She holds a Master of Science with Nursing Administration concentration from the University of Maryland School of Nursing. She completed her Master in Business Administration from the Johns Hopkins University, Carey School of Business in Baltimore, Maryland. She was appointed as Director of Johns Hopkins Health System International Nursing Recruitment at the peak of the nursing shortage, a position she held for 10 years until her retirement from Hopkins in 2009. Since retirement, she worked as a consultant, nursing supervisor, and volunteer for nonprofit organizations. She was past president of PNAA Maryland chapter and member of the Legislative Committee of the Maryland Nurses Association. She is active in PNAA as past chair of the Global Affairs Committee in 2020 to 2021, and currently the Human Rights Committee advisor. So let's give a big round of applause or cheer from your chat to our three guest speakers for volunteering their time tonight. So let's welcome Attorney Angela Librado Trinidad as our first speaker.
Thank you, Dr. Joy, and good evening, everyone, and good morning to all our nurses in the Philippines. I'm seeing a lot of you from the different parts of the Philippines, different islands, and of course, Attorney Vinluan, it's an honor to be in the panel with you, and of course, Virginia. Anyway, a lot of have been asking what POLO is, and let me start off by saying it straightforward that it's a government office. It's not a recruitment agency. It's not a consulting firm, because a lot have been wondering what it is. It is not even a brand of a shirt. It is the Philippine Overseas Labor Office that is now part of the Department of Migrant Workers. It usually, it used to be a part of one department and two administrations, Department of Labor and Employment, POEA, or Philippine Overseas Employment Administration, and OWA. But then last December 2021, a new law was created, and that law sought the creation or the establishment of a Department of Migrant Workers, which will solely be concerned with any and all issues relating to our overseas Filipino workers. Next slide, please. So in the United States, we have two polos. We have Polo Washington, and we have Polo Los Angeles. And you will see on the screen the different areas under which with this two polos where they are under. And so the Polo WDC, which I head, covers all those in the eastern part and the Caribbean islands. Next slide, please. And of course, the next question is, what do we do? We will use also POLO, the acronym, to describe essentially what we do. So we are in charge in the promotion and protection of all our overseas Filipino workers. And these are some of the things that we actually do, and we will discuss that later on. And we also provide on-site welfare services, and including conciliation, mediation, and counseling if ever there are questions relating to contracts of employment. And we also facilitate the issuance of OECs in case our workers in the United States would want to return to the Philippines temporarily on a vacation or a personal emergency. We also enter into labor agreements and cooperation with different agencies and different host countries. So at this point, we had agreements and understanding with the U.S. Department of Labor, and we are in the process of renewing and reviewing the same. And of course, the last one, we have OWA, Overseas Workers Welfare Administration. For those who are members of OWA, those contractual workers, they will be receiving benefits as a consequence of their membership, including assistance to distressed workers and outreach programs. And we also do through OWA mediation and conciliation. So if there are issues and concerns relating to employment, then OWA will provide the services to our office. Next slide. So I think the next question is, why are we here? A lot of workers are saying, hindi naman kami nagbayad, wala naman kayo doon sa pag-uusap namin sa employer, but why is the Philippine government interfering with or intervening in any discussion, in any and all matters relating to overseas employment of our workers? Of course, the Philippine Constitution is our basis. Next slide. Bakit po kami nandito? Kasi ang sabi ng saligang batas, dapat talaga nandito ang gobyerno para magproteksyon or protektahan ang karapatan at kagalingan ng ating mga overseas Filipino workers. So part of the main mandate of our office is to make sure that labor policies and labor programs that are meant to protect the rights and promote the welfare of our overseas Filipino workers are enforced or are implemented. Next slide. As I said, the Philippine Constitution states that we should afford full protection to labor either locally or nandun sa Pilipinas kung gusto trabaho, or overseas. So if you want to go out of the country, we will respect your right to labor, including labor mobility rights. Okay, next slide, please. So of course, aside from that, as I said, the Department of Migrant Workers was recently created, but it also spells out the policies of our Philippine government in relation to labor migration. We do not encourage labor migration as a means to economic growth, but as I said, we will respect your rights. If you want to go out of the country, live temporarily and work overseas. No? So it goes without saying that the United States is one of those countries where we allow the deployment of our workers because, as you can see on the slides, may mga requirements po tayo if we deploy people or our workers to different countries. So I will not venture into discussing each and every one of that, but the requirement should be, if we have to deploy our worker in different countries, that particular host country must have labor laws and social legislations that are favorable to our Filipino migrant workers. Next slide. And of course, isang basis din ng bakit nandito kami is we want to ensure that if our workers are recruited, they will be protected to several principles, one of which would be joint and solidary liability. That's why you are asking, bakit kailangan merong Philippine Recruitment Agency? No? This is actually, these two that you can see right now, these are the reasons why we require the employer or principal to be working with or hand in hand with Philippine recruitment agencies in cases where there are problems arising in the host country. And a right of recourse is limited in as far as the Philippine government is concerned logistically. Then we have a right of recourse against those Philippine recruitment agencies which are in the Philippines. No? So ibig sabihin, pwede nating mapagbayad ang claims, or we can always ask them to report to us on the conditions of the workers abroad. No? So this is one. Second, of course, we want our workers, when they go out of the country, they will have social protection in different forms, one of which would be compulsory insurance coverage. So gusto natin na pag lumabas, babayaran ito at iso-shoulder ng ating Philippine Recruitment Agency. So those are some of the things and reasons why we require our employer and the principal to be working with a Philippine Recruitment Agency. Next slide. So what do we do exactly? Kasi medyo vague yun, no? Protection and promotion. So ano ba talagang ginagawa namin? The first one is accreditation. Accreditation procedure, which we will discuss more clearly later on, and verification, that second one, for the purpose of those workers, whenever applicable, for the purpose of them securing an exit clearance, which we call the Overseas Employment Certificate. Pangatlo, we also do on-site services, advocacy, no? Among which would be post-arrival orientation seminar and other programs relating to the enforcement of anti-labor and human trafficking and anti-illegal recruitment. Next slide. So punta tayo sa accreditation. What does accreditation mean? No? It simply is the government's granting of authority to foreign employer and principal to recruit and to hire Filipino workers. And this is always through a licensed Philippine Recruitment Agency for the purpose of overseas employment. So without regular and ideal situation would be if an employer goes to the Philippines or hires even through Facebook, that particular employee should already have the authority, and that authority is through a certificate of accreditation. The Department of Migrant Workers now has the exclusive authority, but I will invite you to look into the newly issued governing board resolution of the POEA and the DMW. It all now gives authority of the to Polo, to release or issue a certificate of accreditation just to streamline the process. So medyo ang tingin natin mas madali ito kasi hindi na ipapasa sa DMW or sa Pilipinas. Ang Polo na po mismo ang gagawa nito. No? So without an accreditation, please be mindful, without the accreditation, the employer must not hire from the Philippines. And if you want to know whether the employer you've talked to is accredited, the website of the DMW will give you a list of those accredited employers and agencies. Next slide. Of course, how do we accredit? Ang pinakamadali is makita natin yung mga documents na sinasubmit nila, no? And we are hoping that through their documents, we would see whether that employer or principal has a legitimate business or is capable of and has a record of complying with the laws of the Philippines and the host country, in this case, the US po. So makita ninyo ang list of all the documentary requirements that we expect the employer to submit. And very important are the documents which would show how they would treat our Filipino workers to the contracts that they offer us. So in this particular side, you will see a master employment contract. This is the contract that we expect that this employer to be using for you to sign. No, so ito po yung mga documents na gusto nating makita. Next slide, please. So exactly what happens in the accreditation process. The employer or the principal through a Philippine recruitment agency will submit all the documents, and Polo will process the same within a specific period of time. And we will submit, as of this time, we will submit all the documents to DMW, but later we expect that all these documents will just be vetted by us and a certificate of accreditation will already be issued. No, so ito yung proseso po, no? And based on the governing board resolution, there is a specific period of time upon which Polo should be able to address their application for accreditation. Next slide. Of course, the next that we do is verification, both in the accreditation process and the verification of actual employment. Dito po sa verification, what we really want to see are the documentary requirements relating to the contract of that are necessary for the employment of our foreign workers. So contract of employment, mahalaga po yan. We want to see the actual terms and conditions that are reflected in the contract, terms and conditions that are consistent both under US and Philippine laws, kasi we're talking about recruitment in the US and placement in the US. So syempre mahalaga din makita natin yung mga documentary requirements na pwede ka bang lumabas, you have the visa, passport, etc. Now for purposes of the verification of contractual workers, no, mahalaga din ito kasi hindi lang sa purpose of accreditation of the employer but also for the overseas employment certificate. Let's suppose that the employer already has authority to recruit, and then there is already a recruited worker. That worker must submit, or that employer must submit to us the actual contract of employment of the worker, and without which, under ordinary conditions, without which hindi po siya mabibigyan ng overseas employment certificate. As you can see here, OEC is the exit pass or clearance of the workers. If there is no contract, no issuance of the OEC. If no OEC, then there is that worker cannot get out of the Philippines. Now, applicable po ito sa lahat. Next slide po. Well, anyway, this is just a process. Similarly, submit the documents, and then the last one would be the issuance of the OEC. Next slide. Now, applicable ba ito sa lahat? Yun ang tanong ko kanina. It is applicable. The OEC or the exit clearance will be applicable only to medical professionals in this particular case. Ito ang relevant sa ating ngayon. Medical professionals who are holders of visas other than the visa that you see here on the screen or on the slide. Kasi itong mga nurses or EB3, they do not have, they are they have a different type of visa which grants them the right and privilege, actually the privilege to stay here as permanent residents. No? So for the nurses po, ito po ang role ng Polo. Gusto po nating ilinaw to. Accreditation ng employer is done by us, but the individual contracts will not be done, the verification will not be done by us. Meaning, you won't be required to have an OEC. But that is also the reason why some of you may not know about Polo, may not have heard about us. Kasi ang palagi namin kinakausap is yung inyong employer. So for all the nurses who are listening right now, even if you're not dealing with you individually, please, if somebody or an agency or an entity approaches you, please make sure that to know whether that particular agency or that particular representative of an agency, that agency is accredited by the Philippine government to the certificate of accreditation. Next slide, please. So doon sa ating, may mga tanong at gusto ko lang sagutin, no? Pwede bang i-direct hire kami? The rule on direct hire has been there for the longest time, even older than us. No, i-claim ko na po sa lahat ng mga nurses yan, i-claim ko na magkaedad tayo. The rule is that direct hire is prohibited. No, and there are some exceptions to the rule, and I think what is relevant in this particular case is one particular exception where a worker could be hired directly if and when, next slide please, the one who is being hired is a professional or skilled worker. That's the one. Siguro applicable dyan of course, applicable dyan ng nurse kasi professional. Pangalawa, pero may condition ito, dapat yung kontrata is over and above the standards set by the Philippine government. An exception to the exception, if you have all the conditions, you're a professional or skilled worker, you have a contract that is superior than that of the standards set by POEA or the Philippine government, the particular employer must not exceed a total recruited employees that must not exceed 5, no? So 5 lang po at cumulative ito. Siguro may na-recruit na 1990 tapos may na-recruit na 2000. Pagsasama-samahin po ito sa ngayon. At also as of this time yan po ang rule natin. No, so the particular employer must not exceed a total number of 5 recruited workers. Next slide. So for those who are also asking whether we have regulatory powers and we have the power to sanction employers, yes, we have. No, in the light of our campaign against illegal recruitment and against human and labor trafficking, first we have the power to suspend accreditation of that employer, but kailangan po namin ng reklamo. Pangalawa, aside from the suspension of accreditation, disciplinary action could be filed before the DNW. And I will not venture into discussing all these grounds. Suffice it to say that, of course, if that particular employer will have problems with anti-illegal recruitment and human trafficking laws, then they could be subject to suspension or disciplinary action. The third one, of course, aside from the suspension, pwedeng ma-revoke talaga ang kanilang accreditation certificate. So the question is, do you have, if ever you have questions or complaints, do you have recourse even under Philippine laws, even when the employer is here? Yes. And these are some of the reliefs that you could avail of. Next slide. And I am segueing to those reliefs because these are some of the issues that we have gathered by far. And the first one is contact substitution. And we think that contact substitution, although it is not illegal per se, pwede mo nang palitan ng kontrata. And I think Attorney Vinluan will be able to explain that. But contact substitution for us is irregular. And if it is irregular, it is problematic. No? Hindi pwedeng mag-switch lang ng kontrata na hindi naman nakapagpaalam, no, sa Philippine government, because remember that during the accreditation process you must submit a master employment contract, and if that contract is substituted rightly, that employer must also inform us that the contract has already been substituted by a new one or the provisions have been amended. Second, questions on contract and what are these question relating to contracts. The first one is form. May nagtanong sa akin kahapon lang na Ma'am, wala kasi akong kontrata, meron akong offer of employment. So mamaya siguro i-discuss si Attorney Vinluan kung what are the possible forms. But suffice it to say that in the United States, we know that a contract could be in any form as long as there is meeting of the minds. But in the case of the Philippine government, we are very strong on these mandatory provisions. Of course, they are mandatory. That's why we are strong on that. Medical insurance, we want to know how the employer treats it. Repatriation, whenever applicable, we want to know how the employer will deal with it. 3, termination clauses, which is very important to us. Hindi po pwedeng basta-basta lang na mapaalis or kung meron man, ano ang pwedeng consequence. And then the 4, free transportation from the time of hire to the host country. And aside from the form of contract, second is on issue of liquidated damages specifically. No, in sometime in 2020, please note that we have already done away with any provision relating to damages. Pag may nakita kayong kontrata na may liquidated damage or damages, problematic po yan, and please call us or email us, no, so that we can advise you accordingly. Next slide. So in lieu of that, ito po dapat ang makita na ninyo sa kontrata. No, if there is breach, there is potential breach. It could be breach, but it should not. The relief or liquidated damages or payment of damages should not be mutually exclusive. It entitles any of the parties to legal remedies, but it is not solely recoupment of expenses or liquidated damages. No? So ito na po ang dapat na makita ninyong form doon. Next slide. So kung may mga tanong pa kayo, ito po ang aming, please take screenshot of our details, and we will entertain questions after the entire presentation. And thank you so much for this opportunity again. And now I will turn you over to Attorney Felix Vinluan to discuss more about contracts. Thank you.
Thank you, Attorney Angela. Good morning, good afternoon, and good evening, everyone. I'd like to start my presentation on international nurses recruitment with a brief description of the immigration sponsorship process. Next slide, please. Healthcare facilities such as hospitals, nursing homes, and staffing agencies are almost always the ones sponsoring registered nurses to come into the country. When they do sponsor nurses, they start with securing what's called the PWD, the prevailing wage determination. That's the wage rate that they are supposed to pay their prospective employees. And they also file what's called a notice of filing, so that at least their employees will be able to know that they're looking for immigrant workers, because the job's supposed to be offered first to a US worker. And then after they have done that, they file what's called the Form I-140 petition for immigrant worker with the USCIS, with the US Citizenship and Immigration Services. That's when they ask you to sign what's called the Form ETA 9089. So if you're a nurse being sponsored, you have to sign one page, page 9 of the Form ETA 9089. The two issues that are relevant in a Form I-140 petition are first, financial capability of the employer. You have to make sure that the employer has the financial capability, otherwise the petition will be denied. And secondly, the RN beneficiary should be qualified, which means the nurse should have at least not a bachelor's degree, an associate degree, because here in the US we require only an associate degree for an RN position. Plus, the nurse beneficiary should have license in the state of intended employment, or is eligible to secure a limited permit or a reciprocity license in the state of intended employment. Once the I-140 petition is approved, then the second step of the process kicks in, which is with the National Visa Center. So the fees are paid, and then the DS-260, which includes all the information about the beneficiary and his or her family members, and then civil documents or birth certificate, copies of your passport, as well as your NBI clearances are going to be submitted. After you are documentarily complete, when you hear that term, you're documentarily complete, then you'll be scheduled for your medical appointment with St. Luke's if you are in Manila, and you'll be given a date for your consular interview. Just very important thing for RNs, for registered nurses, that you should be able to have your visit screen certificate at the time of your consular interview. Next slide, please. When you get sponsored as an immigrant worker in the country, almost always, I haven't seen any employer yet that hasn't required an employee or a beneficiary to sign an employment contract. Let's discuss what a contract is. Attorney Angela mentioned a while ago, a contract is a meeting of the minds. And under our civil code there in the Philippines, they define it, contract is defined as a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So there is an offer and there is an acceptance. And there's also be a consideration. There's an agreement to exchange something of value, which could be money, goods, or services. And the parties to the contract should intend to be bound by the terms and conditions of their employment. They should consent or agree on all the essential terms of their contract. So what is an employment contract? An employment contract generally is a written agreement between an employer and employee that outlines the terms and conditions of employment. This written agreement could be nominated as an employment agreement or a contract of employment, or it could be a letter, an offer letter of employment. Okay. Now, when we talk of an employment contract, it is very important for, in this case, the nurses, to know what their rights are with regard to the contract. It is your right as a party to a contract to negotiate the terms and conditions of your employment contract. You should own and exercise your right to negotiate. Here in the country, we really need nurses in the US. So you have the bargaining chip actually. You just don't sign any contract that's being given to you by your prospective employer or prospective sponsor. It is also your right to seek, next slide please. It is also your right to seek the advice of your own lawyer in reviewing the employment terms and conditions. So next slide. Specific provisions found in an employment contract. First of all, the identification of the parties. Who are the parties to the contract? This is very important because it will tell you who the employer is going to be. Is it going to be the healthcare facility that's sponsoring you, or it's going to be somebody else? It will also tell you the address of the employee, of the employer. The second term is the effective date. In employment contracts, I have seen variations on the effectivity date of the contract. Sometimes you're given a 3-year contract that starts upon your arrival in the country. I have seen contracts that have effectivity dates starting upon the full licensure of a registered nurse. So if the nurse doesn't have full license yet at the time of his or her arrival in the country, the contract doesn't start. So in that way, sometimes the employer gets like, a freebie. And sometimes the contract would stipulate that the effectivity date of a 3-year term, for example, would start upon commencement of work. So what if you come into the country in January and the employer doesn't give you a job until maybe March or April? So you lose time. Okay. So when you negotiate your contract, you better make sure that the effectivity date, the best option there will actually be upon your arrival in the country. Third term is compensation and benefits. When we talk of compensation and benefits, we talk of how much you're going to earn when you perform your duties and responsibilities as a registered nurse. Will it be hourly rate? Will it be on a salaried basis? When you are sponsored as an immigrant worker, like I told you earlier, the employer secures what's called the prevailing wage determination, the PWD. That's the rate that the employer is required to pay you. So, for example, your employment contract says that you're going to be paid $30 per hour, but the prevailing wage rate is a little bit higher than that. Okay, you have the right later on to complain that the law is not being followed. Okay, another term and another provision on compensation and benefits would be reimbursement of licensure and credentialing expenses. Who's gonna pay for these things? Although immigration rules and regulation do not require an employer to pay these fees, I think it's part of your bargaining chip because you're really in demand here in the country to ask the employers to pay for your licensure expenses as well as your accreditation expenses. Now, you also talk about health benefits. Attorney Angela mentioned a while ago that they require now compulsory medical coverage. So that's something that you have to discuss with the employer as well. How much you have to pay, if you have to pay at all, any contribution to your premiums. You also have to discuss about housing or accommodations. How many months would be given to you by your prospective employer as freebie? Okay, would you be given free housing for 3 months or 6 months? You also have to discuss with them about orientation period. How long will be your orientation be? It's supposed to be paid. Sometimes the contract might say you will be paid less than the prevailing wage rate. You know, that's something that's unlawful and it's being questioned in some cases nowadays. You also have to discuss about meal periods and break times. Under the law, you're supposed to be paid during those times when you are working. Because here in the States, even if you're actually supposed to be doing your meal break, you're still being required to work. So if you are being asked to work, you should ask your employer to pay you. Okay. Number 4, the duties and responsibilities. Okay. I know you're going to sponsor as registered nurses, but sometimes when you come into the country, you don't work exactly as a registered nurse. I have seen newly arrived nurses doing the job of a registered nurse supervisor. So make sure that you get the correct duties and responsibilities, because if you are asked to work as an RN supervisor, they should be asking your employer to pay you the rate for an RN supervisor. Number 5 will be term or duration. Normally, we understand this to be like 1 year, 2 year, or 3 year contract, but I have seen contracts whereby the employer requires the employee to work certain number of hours during a 1 year period. So for example, in 1 year time, they will ask you to be working 2,000 hours. So during a 3 year period of time, you should be working at least 6,000 hours. Problem there, and you have to confirm this with your employer before you even come here, is what if they can give you full-time job during a week so that you cannot really fulfill the 2,000 hour requirement during 1 year period of time. Okay, next slide, please. Number 6 will be grounds for termination. Okay, there could be grounds, valid grounds for termination. The employer may write down, for example, if an employee commits a crime or is willfully disobedient or commits serious misconduct. Those things are grounds for termination. Or commits fraud, okay, then the employer may terminate the employee for cause. There should also be grounds for termination by the employee, okay, vice versa. So these are the things that you need to discuss with your employer at the time that you're being sponsored. Next would be mechanisms to settle disputes. When you do have a grievance or a complaint against your employer, sometimes your employment contract provides that you have to give them some time, like maybe a 30-day notice for them to be able to cure your complaints. Now, if that doesn't work, sometimes you engage in conciliation and mediation. That's why Attorney Angela mentioned a while ago that the polo is there as one avenue to settle disputes. I have seen contracts too that would require the parties to go through arbitration. You know, the difference between mediation and arbitration is that in arbitration, the arbitrator or the arbiter makes a final and binding decision. Okay, and if I were an employee, I wouldn't really do that because there are some negative effects on an employee's part. Number 8, restrictive covenants. When we talk of restrictive covenants, we remember non-competes, non-solicitation, and confidentiality. Non-compete, you're not supposed to be working for any other employer other than your petitioning employer, okay, for a certain number of time or for a certain number of months or years, and within a certain radius from your employer's facility address. Non-solicitation means you're not supposed to siphon off or get other employees of your employer to be working for you or for some other employer, or to be taking the clients of or patients of your own employer as your own. With regard to confidentiality, employers almost always require the employees not to disclose trade secrets or financial information. Number 9 would be liquidated damages. What are liquidated damages? Attorney Angela mentioned a while this ago. Liquidated damages are supposed to be estimate of what a party at the time of entering into the contract would deem as the extent of its damages should one of the other party breach the contract. Okay, next slide, please. One other term, I'm sorry, back. There is one more. The number 10, applicable law. Employers also require in the employment contracts the state law that would prevail or that would govern the interpretation or enforcement of your contract. So if your employer is located, for example, in Ohio, they will say the law that would govern this contract would be the law in Ohio. Or if it's in Florida, it's in Florida. Now, in addition to the applicable law, they also sometimes put down clauses such as waiver of jury trial, okay, or which means you cannot go to court and ask for a jury trial. They also sometimes require an employee not to be able to file any case if they have to go through arbitration. They cannot file a case in court, and if they cannot file a case in court, they can even file a case for a class action. Okay, next slide, please. A breach of contract. Now we have seen the important terms and conditions of a contract. There is a breach if we can prove these four elements. First, that a contract has been formed between two parties. One party performs, that's normally the plaintiff, and one party does not perform, which is the defendant. And as a result of the failure by one party, it could be the employer, it could be the employee, damages is suffered by the non-breaching party. Next slide, please. Let's talk about material breach of a contract. A material breach of a contract is such breach or the failure to perform the contract that it strikes deeply at the heart of the contract, that it renders the contract irreparably broken and defeats the purpose of making the contract in the first place. So what is material really is very difficult to state. It depends on the facts of the case. So courts generally consider the extent to which the non-breaching party will be prejudiced or damaged by lack of the full performance by the other party. Next slide, please. When a party to a contract breaches the contract, the other non-breaching party has a relief. They can go to court and file for damages for the breach of contract. Or they can ask for injunction. They can ask the court to order the other party to stop doing what it's doing, the thing that it's violating. Or they can ask the court for a declaratory relief, which means ask the court to declare that that action which is being threatened, for example, or is being done by the other party, which is breaching the contract, is unenforceable. Next slide, please. When we talk of an employment contract that is being breached, almost always in the cases that I've seen here in the States, we talk about labor trafficking. Because when an employer or an employee, more likely the employer in this case, breaches the contract, the employee states that they are being trafficked. So what is trafficking in persons? Trafficking in persons is defined as the recruitment, the transportation, transfer, harboring, or receipt of persons by means of the threat or use of force or other forms of coercion, of abduction or of fraud, of the abuse of power or a person having control over another person for the purpose of exploitation. Next slide, please. Exploitation shall include at minimum the exploitation of the prostitution of others or other forms of sexual exploitation, forced labor or services, slavery or practices similar to slavery, servitude, or the removal of organs. And this definition comes from the Protocol to Prevent, Suppress, and Punish Trafficking in Persons of the UN Convention Against Transnational Organized Crime. Next slide, please. In the US, there are two kinds of trafficking that we talk about. It's either labor trafficking or sex trafficking. And our laws here in the US codifies labor trafficking as forced labor under 18 USC section 1589. And the text of this law creates civil and criminal liability for whoever knowingly provides or obtains the labor or services of a person by anyone or by any combination of the following means. There are four means. Number one, by means of force, threats of force, physical restraint, or threats of physical restraint to that person or another person. So there is a physical force that's being used. Okay. Number two, by means of serious harm or threats of serious harm to that person or another person. So for example, the employer would tell the employee, if you don't continue working for so many number of hours, I'm going to cancel your immigration sponsorship, okay? Or I'm going to report you to immigration to be deported. That's a serious threat. So if an employee continues working under such condition, that employee is being trafficked because that employee is continuing to render services involuntarily. Number three, by means of the abuse or threatened abuse of law or legal process. So case law here in the States, there are a lot of them that says an employer that threatens to sue an employee, for example, liquidated damages for X amount of money, like $30,000 for not performing, for not continuing the job. That threat is considered as an abuse or threatened abuse of law or legal process. Okay. And number four, by means of any scheme, plan, or pattern intended to cause a person to believe that if that person didn't perform such labor or services, that person or another person would suffer serious harm or physical restraint. Next slide, please. And 18 USC section 1590 defines what's human trafficking. Human trafficking, section 1590 provides liability to any person who knowingly recruits, we are talking now of recruitment, who knowingly recruits, harbors, transports, provides, or obtains by any means any person for labor or services in violation of this chapter, which means section 1589 on labor trafficking. So I end my discussion with that. I'll be more than happy to answer your questions later on. So I'll turn it over now to Miss Virginia.
So I know that Virginia is logging in from the Philippines, and if she can just unmute herself so she could start her presentation, please go ahead.
Sorry, I started talking. Okay, so I've already I've unmuted myself. Thank you. So yes, I'm calling from the Philippines. So thank you so much. And as I mentioned, I mean, we appreciated the nurses who willingly share their stories and their narratives about their experience, especially the most recent arrivals. And we got this through the PNA sub-chapters and also through the Human Rights Committee of PNAA. So as Marife mentioned, we have the PNA through its committee we have a formalized process to address effectively some of these concerns that people raised to the Human Rights Committee. I wanted to load this in terms of the three categories: workload management, contract issues, and onboarding issues, because it seems like these issues are coming up more often than any other issue. There's so many, but I wanted to just zero in on these three areas. So on difficulties in managing workload, this may range from inadequate orientation. Some of you may get a contract to say, oh, when you come here, you will have 4 to 6 weeks orientation. And some people may have 3 months orientation. So what do you do if you feel that after your period of orientation, you're still not adequately prepared to carry the workload? So those are the issues that you need to address with your employer or with your staffing agency, whoever is your employer. The other critical piece that we are seeing more and more are the nurses who are coming to the US without clinical experience. So they get ads to say like, oh, no experience is necessary. As long as you have an RN license, we can sponsor you. So what happens is when they come to the US, they are clinically don't have the clinical competence or even the confidence in their skills. So the adjustment period is even more difficult. So that's why we always stress to people, I said, you get so excited about coming to America, but please make sure you also have a responsibility to yourself to make sure that you are clinically confident and clinically competent in your basic nursing skills. The other piece that is assignment of to a facility or a unit where it does not match your clinical experience. So for example, I get a call from a nurse who said, I am an ICU nurse. I've always been an ICU nurse and I'm assigned to a nursing home. Well, that is a total mismatch of skills to the person's experience. A critical care nurse in an acute hospital is used to high tech, really adrenaline pumping area, and then you're assigned to a nursing home with 1:20 or 1:40 nurse patient ratio. So the nurse was struggling on how to manage that. So as my old colleague who is a geriatrician used to say, Virginia, the nursing home is more of a high tech and high touch, low tech, high touch and low tech, and your ICU setting is more of a high tech and high touch. So make sure that when you get an assignment, your assignment matches your clinical experience. And of course, the other piece that you have to remember is, I know as a newcomer, your communication skill probably needs to be honed a little bit more. So we need to be able to assist you in basically how do you communicate more effectively in a work setting, your communication styles, and of course, it depends on what part of the country you're in. Contract issues, I think Dr. Benluan and Attorney Librada has already touched on this, but this is a very common issue that comes up to us. So many times we'll get calls to say, how do I get out of this contract? I don't like it. It's not fair. It's not safe. I'm not comfortable working in this area. So we need to make sure that you understand your contract, you read your contract, and you basically do what you need to do in order to, from the very beginning, understand the content of that contract. And one of the key elements, I think we as nurses are always been told, document, document, document. So if you have an issue with your employer or with your agency, make sure you document everything. Print everything that you have that is in your, keep a copy of everything. And also, if you have a verbal interaction with the person or with your employer, make sure you document that by saying, this is my understanding of our discussion on this date in relation to whatever issue you discuss. The reason for that is so you have a common understanding what has been agreed upon. So Documentation is very critical, so you have to make sure you document everything and you keep a copy of all this documentation. Let's see. Then I want to do the onboarding issues. This one is pretty loaded because many a times I get calls to say like, Miss Virginia, I'm here in Baltimore. My agency gave me a month's stay in a hotel, and can you help me find housing after I finish this 1 month stay? So my response always to this person is, who is your agency? They're supposed to help you find a permanent, at least, some temporary housing while you're getting all these pieces together. So, we usually struggle to say, okay, let's see who we know who can help this person get at least find a housing. But the accommodation, it seems to be, is coming up as a very common issue that comes up. Or they come in and then they are picked at the airport and they go to the apartment that is empty. Can you imagine traveling 32 hours, you're tired, and you get an apartment, then you ended up in an apartment with nothing. There's no bed, there's no chair, there's no table, and there's no food. So you want to make sure that when your employer or whoever is sponsoring you meet you at the airport, you are in an apartment that is furnished, meaning it has a bed. It has a bed. It has the kitchen facilities, and it has a table where you can eat. And also, at least for the very beginning, give you enough food to last you for at least 3 days until you can find your way around. And so the other piece is childcare concerns. Some nurses don't understand that, or at least they do not take that into consideration. That my advice always is, if you have young children, maybe under 5, come to the US first, get settled, get yourself situated, get your orientation through, and then bring your children over, or maybe your spouse and the children over. So that way you have somewhat acclimated to the place. And also keep in mind that in most cases, your medical insurance kicks in a month after you start employment. So if you bring your children with you right away, if they get sick, you're personally responsible for the medical expenses of that child, and medical cost in the US is not cheap. So you have to keep that into account. So the first month, probably when you arrive to the US, you don't expect to work, arrive on Friday, don't expect to work on Monday. It's because you still have to get your Social Security card. If you are not licensed in the state where you're supposed to be practicing, you still have to do your license by endorsement. And in order to get the license of endorsement, you have to have your Social Security. And Social Security can take 2 to 3 weeks. So you cannot do anything until you get the Social Security. And then you can apply for your license by endorsement. You still have to do your pre-employment physical. You can do that without your Social Security, but although you have gone through the extensive pre-employment medical exam at St. Luke before arriving, the employer would still require you to go through the pre-employment physical. It's very specific, the organization. Opening a bank account. So you need your Social Security in order to open a bank account. Sign a lease. In order to get your apartment, for a long term, you need to sign a lease. So somebody has got to help you navigate all of these complexities when you come to the US. I know that many a times our local chapters would say, oh, we're getting calls from nurses who just arrived and then they need a vacuum cleaner, they need a rice cooker, they need pots and pans and everything. So I think we need to do a better job and setting some of those standards so that we do expect employers, or at least assist employers to prepare nurses, because some of that are probably not, they don't think about it. So our role is to make sure that we assist in that endeavor. Next slide. So the PNAA, so for some of you who have not really been, are new to the Philippine Nurses Association of America, we have been advocate for nurses for a long time. So removing barriers for Filipino nurses to practice in the US is one of them. And then the petition to remove or modify the CGFNS certification program requirements to take NCLEX, for example, in New Jersey, Virginia, Indiana, and recently in Michigan. So what's happening is there's an additional barrier, in some of those states to say, if you want a license by endorsement, if you have the NCLEX, you still have to take the CGFNS certification exam. So our argument then was the CGFNS certification exam is already obsolete, because in the old days, when we have the CGFNS certificate, that was when NCLEX was not offered in the Philippines. So passing the CGFNS exam then was a good predictor for the nurse to pass NCLEX. So you can sponsor a nurse with CGFNS certification for a green card pending, then they still have to take the NCLEX. So when NCLEX was introduced, some states still kept that provision in their board regulations. So we were able to address some of that, and I think there's still about 6 states that has CGFNS certification exam in their books. And I want kudos to the Philippine Nurses Association also for bringing the NCLEX to the Philippines. And this was done in 2007, correct, Lolet? And this was after all the negotiation of question about the technical aspect of it, the integrity of the exam, the confidentiality, and the security. So when all of those things were addressed, then they were able to provide those NCLEX examination in the in the Philippines. So in fact, they're now offered over almost everywhere. Now, the Global Affairs Committee and Human Rights, one of the pieces that we're very proud of the work that we have done is the first publication of 2021 handbook for Filipino nurses immigrating to the US. I highly encourage everybody, every single person attending this conference who is starting their journey, to please read this handbook. You can download it, it's in a PDF file, and it's free. So that's the end of my presentation.
Thank you so much. And I can see that our chat and our Q&A is really on fire. A lot of responses there. So Mary Faye, take it away. Mary Faye might still be on mute. As you can see here on the screen, we have our save the dates. Go ahead, Mary Faye.
We would like to thank our excellent speakers who contributed to the success of this webinar, the first of the 4 webinars that we're having. And the second webinar is scheduled for December 12, titled Nurses Narrative and Lessons Learned. The third will be January 11, 2023, Resources for Newly Arrived Nurses. And Series 4 will be decided. Now we are open for question and answer.
Good morning, everyone. This is Madeline Yu. I'm chair of the Global Affairs Committee of the Philippine Nurses Association of America. M?
Good evening, everyone. Good afternoon. Magandang umaga sa mga kababayan in the Philippines. My name is Emily Danuco. I'm the co-chair of the Global Affairs Committee.
We are both here to facilitate your Q&A, and looking at the time, Chairman and moderator, do we have an extension of 10 minutes to at least go through some of the questions?
Absolutely. I know this is a very hot and important topic. So yes, we will be able to extend for another 10 minutes. Go ahead.
Thank you very much. So I've seen that Attorney Librado Trinidad has put in the chat box the link for questions regarding accreditation. So we're not going to read any more questions on accreditation. Please refer to the Polo link posted by Attorney Trinidad. My first question is, are there 2 contracts, one between the nurse and the agency and one between the nurse and the hospital? Attorney Vinluan?
As I understand your question, you're asking if there are 2 contracts? between
Yes, that seems to be the question that the nurse is asking.
contract between the nurse and the hospital,
And the
then
agency, and then the nurse and the hospital.
okay, this is a situation whereby the hospital uses an agency to recruit a nurse, and then that nurse is going to be assigned to be working at the hospital. The employer in this case is the hospital. So this happens really when the hospital does not directly recruit a nurse. For example, in the Philippines, it uses an agency to recruit one. Although there are also some agencies, like I mentioned a while ago, that are the direct employers of the nurse themselves. So in this question, it is okay for the hospital to have its contract with its recruiter, and the hospital to have another contract with the nurse that's going to employ.
Thank you, Attorney Binluan.
So the next question, I think this is probably for Attorney Trinidad. Are the health and medical benefits offered by employers mandated to be offered on day one, or waiting period by employer, like 3 months is okay?
I think based on what Attorney Binluan and I had discussed, the requirements must be both based or in accordance with Philippine laws and US laws. So in this particular case, if the insurance coverage in the US and based on American laws would require that this would be effective at a particular period of time, I think that would be acceptable to the Philippine government. That is also precisely why, as a matter of protection and as a mechanism, we require that the Philippine Recruitment Agency would secure coverage for our medical professionals or our OFWs, just in case. Because in the interim, our workers will be protected. That's the first one. And second, if I may be allowed, let me just make a comment on the first question. Well, we also respect that there are contracts that could be entered into by nurses with recruitment agencies, nurses with employers. What we are very most concerned about are contracts that nurses enter into with agencies where there are additional burden and additional conditionalities for our nurses, which are not even covered in the original contract between the employer and the nurse himself or herself. So we want, and we have been talking to employers, we want all of them to be transparent, because that's part of ethical, fair and ethical recruitment practice, for them to be transparent in the contracts that they require our nurses to enter into. Because entering into a contract is, it's not illegal, but it becomes questionable and it becomes tricky when our nurses enter into different types of contracts where additional burden is given to our nurses unnecessarily, and that's where the problems usually arise. Thank you.
Thank you, Attorney Trinidad. Madeline, next question.
Yes. Is it lawful for an employer to create rules to exclude contracted immigrant nurses from getting overtime bonus pay over regular employees? Anyone from the panel?
I have a question. What regular bonus pay?
The question, I believe, is asked if it's lawful for an employer, a hospital or a skilled nursing facility or a nursing home, to exclude contracted immigrant nurses from getting overtime bonus over the regular employees.
If they are all employees, why should they be discriminated against? That's how I'm going to answer that question. Just because they are immigrant workers does not make them a separate category or class from homegrown registered nurses who are employed also by the same facility. So that would be discrimination on the basis of one's ethnic background or nationality.
Correct. I would agree with Attorney Binloan. Once you arrive here, you're all registered nurses. There is no label that would say you're immigrant, you're a homegrown nurse, and everyone should have the same rights and privileges afforded to all nurses in America, correct?
Yes.
Thank you, Attorney. M?
The next question, I think for either one of you, but if a hired nurse hasn't gotten her licensure, she usually not paid the contracted salary until she or he passes the board. Is that correct?
I'd like to question the premise there. The hired nurse entering into the country without a license. I don't know why the employer would be able to bring that in if that nurse is not qualified. Okay. Now, if the case is that the nurse has a license from a different state and the nurse is just undergoing reciprocity to get a license in the state of the sponsoring employer, the employer, however, has made an attestation or a promise with the US government that upon the arrival of the nurse employee, the beneficiary, that employer is going to pay the prevailing wage rate. So the nurse, if I were the nurse's lawyer, I would argue that the employer should still be bound to pay the prevailing wage rate for the position of a nurse. Although the licensure, for example, is not a full license yet.
Thank you, Attorney. Madeline?
This situation was brought to me a few days ago from Richmond, Virginia. What if the employer hired them as an RN, but the agency used and used them as an aide? Apparently, there were groups of nurses who arrived in Richmond, Virginia, who were hired as RNs, but are being used as aid. That's the report from Richmond, Virginia.
That's clearly a breach of the contract if they were hired as registered nurses.
I believe on my own, I advised them to present the case to Human Rights of PNAA and to Polo. How else would you advise this group of nurses to move forward?
Like I discussed earlier, they have relief if there is a breach in their employment contract. Take a look at their contracts. What are the available mechanisms for them to settle their disputes? Normally, because I am a lawyer, I would advise them to file a complaint in court, either in a state court in Virginia or in federal court, if there are violations, for example, of how they're getting paid.
Thank you, Attorney Binloan.
The next question, I think this is for Attorney Binloan as well. Are there situations wherein the contract can stipulate the penalty for breach of contract that includes the amount of money or termination or sponsorship of visa?
That's what we have seen in a lot of employment contracts. Employers provide X amount of money as liquidated, quote unquote, liquidated damages should the employee or the nurse not fulfill the term or duration of the contract. So in a lot of cases nowadays, courts have been saying that if these employers have been recruiting and employing Filipino nurses for several years now, they would have known at the very outset how much damages they would incur if a nurse pre-terminates his or her contract. So the damages are easily determinable at the outset. So that's not even a ground now for the liquidated damages provision to be enforced by the court. Secondly, if these contracts were entered into by the Filipino nurses as a take it or leave it, okay, they are forced to sign, otherwise they will not be sponsored or they will not be able to come here to the US even after their petitions have been approved, then courts here would say the bargaining the negotiating bargaining power of the parties are not equal. So these are termed like a contract of adhesion, and most courts don't enforce this kind of liquidated damages.
Thank you so much, everybody. Thank you for your answers. It's 11:16 Philippine time, and I'm sure it's 10:16 p.m. Eastern Standard Time, and we have gone over our proposed time limit. We will read and go through all your questions and post the answers on our website in PNAA website at mypnaa.org. Going back to you, moderator.
Thank you so much. I know that a lot of questions have been answered, but there are still more that we will probably go through and share this between Attorney Venluan, Attorney Librado Trinidad, and Miss Virginia Alinsao. We will collate the questions, and as what Madeline had said, we will post this on our website once we have the appropriate answers. But more than happy to communicate moving forward with anyone that would like to reach out to PNAA. Info, mypnaa@gmail.com. And please watch out for the save the date for our next series webinar that will really focus on our nurses' narrative stories, and more to come as we continue to address issues of recruitment and ethical processes with the workplace environment. Magandang umaga sa Pilipinas, magandang gabi sa inyong lahat, and maraming salamat sa mga nag-participate tonight. Thank you to our guest speakers. Have a good night.
Good night.